Attorney General Eric Holder is reportedly weighing whether to open broader civil rights investigations into the Ferguson Police Department. One of the cases the Justice Department is looking into happened in 2009. The Ferguson police left an innocent man beaten, suffering from a concussion, with a ludicrous charge for bleeding on police uniforms. On the night of September 20th, 2009, police officers in Ferguson arrested a man named Henry Davis, suspecting him of driving under the influence. They took him to jail, where the 4 officers allegedly beat him. One of the officers, Kim Tehan, allegedly struck him in his head with a closed fist and hit him in the head with handcuffs. Davis testified, quote, "They started hitting me, I was getting hit, and I just covered up." Davis insisted he be photographed to document the beating. A warning, the photo is graphic. Davis said another officer kicked him in the head, at which point he suffered a concussion and almost passed out. Davis had been arrested for an outstanding warrant, but the police had the wrong suspect, one with a different middle name and social security number. Davis was held several days before being charged with 4 counts of property damage for bleeding on the police officers' uniforms. He filed a civil suit, but in December, the claim was thrown out. His lawyers appealing that ruling. Joining me now is Henry Davis's lawyer, James Shottle, who is currently preparing an appeal on his behalf. Thank you for being here.
No problem. Thank you for having me, Al.
Now, his first civil suit was thrown out. Well, what do you think Mr. Davis' chances are winning this appeal?
The rulings by Judge Baker, we felt the judge completely erred, particularly on the excessive force claim. She held that Mr. Davis's injuries were de minimis or minor. There has been no ruling in the Eighth Circuit whether a concussion is a minor injury, and we strongly feel that it is not a minor injury, and that the case should not have been dismissed on that count. Mr. Davis testified that he had a concussion from being beat in the head and kicked in the head, and he still to this day suffers from headaches from that injury.
But Attorney Shottle, concussion or not, what about the ludicrous notion of beating a man who was the wrong man, and you charge him with bleeding on your uniforms while you were beating him? I mean, what about the fact they shouldn't have been beating him at all? I mean, concussion notwithstanding, what about that?
Well, we agree, and you know, in these civil rights cases, they're very difficult because you have to overcome the hurdle of what's called qualified immunity, where officers, you know, can, you know, use force on people, yet they're entitled to qualified immunity. It's a long line of legal cases.
So wait a minute, let me get this right. So an officer has the legal right to assault me, beat me, charge me with bleeding on them from a beating they gave me, and as long as I don't rise to a certain level of hurt, like a concussion, there's nothing I can do about it?
That's true based upon this Eighth Circuit case of Chambers is what it's called. If the injuries are de minimis or minor, an officer can be entitled to qualified immunity. Now, those charges and them being false that we alleged, and you know, and actually had some significant evidence that they were false, that's a separate issue. That's a due process violation, where the law is pretty clear that an officer, if he creates false evidence or makes false statements to you know, create the charges against someone, and that person either pleads guilty or is found guilty, that's a due process right to a fair criminal proceeding.
Well,
and that count is also on appeal. How
do they explain the blood on their uniform? How do they explain how he was bloodied?
Well, actually, a couple of the officers in their sworn deposition testimony said that they didn't have blood on their uniforms that night. So we don't even think that the actual accusation of the blood on the uniform is true. But
wait
none
a
of
minute. They charged him with blood on the uniform as the property damage, but then they said they didn't have the blood that they charged him about?
That's correct. That was their deposition testimony that was presented.
How do you explain that?
That's a good question. They had no explanation for it, even at trial. And, you know, well, we were shocked that even halfway through the trial, the judge said that the actions of the officer did not shock the conscience. And I think that's a shocking thing to have an officer tack on or pile on charges based upon false statements.
Were they charged with perjury?
They were not. I think they should be investigated for it because their testimony is on the record.
I want our viewers to know that one of the former officers, Kim Tien, who hit Mr. Davis with handcuffs, has been allegedly hit him, I should say, has been elected to the Ferguson City Council and is now serving a 3-year term as one of the 5 whites on the city council in Ferguson. Does that make your job more difficult to prove the case that you're dealing with a city council member?
No, it really doesn't have any bearing on our case. And you know what's going to be looked at in our case. And I just learned that Officer Kim Tien was now on the city council. Okay. I had no idea. But what'll be looked at is the events on the September 20th, 2009, and you know how that police department was operating, because we also did sue the city of Ferguson with respect to how they were reporting use of force reports, right, how they were keeping track of civil rights complaints. And that issue is also on appeal before the 8th Circuit.
Well, please, Attorney Sharpton, keep us informed on how this proceeds. But I can see why this would catch the Justice Department's interest, because it certainly caught mine. James Sharpton, thank you for your time tonight, and please keep us posted.
Will do. Thank you, Al.